Hello and welcome to this lecture where I'm going to cover the topic of the Irish court system. So I'm going to introduce you to the Irish court system and the structure. So we look at the administration of justice as one part of the court system, and then we will look at the structure of the court system in Ireland, which follows a hierarchy of the hierarchy of judicial decision making, or the hierarchy of the courts. So the purpose of the lecture is to allow students to be able to achieve particular learning outcomes, and in the context of the Irish court system I'm going to take you through a lecture that will allow you to be able to compare and contrast the jurisdiction of each of the courts within the hierarchical judicial system, and to be able to identify and explain the role or the jurisdiction of each of the courts and the constitutional foundations for our court system and the structure of our courts. So initially we had a court system that was set out. The provision was founded in the 1922 Constitution, and this provided for a court system that was later established in the Courts of Justice Act 1924. But this court system was based on British rule, and the Constitution of 1937, Bunreacht na hÉireann, the new Constitution in Ireland, our current Constitution, set out the provisions or the foundations for the development of a new court system that would remove us from the old British rule and British influence. So if you look in the Constitution, you'll find within Articles 34 to 38, they set out the core foundational system of the Irish court system. So the court system, as I said, the foundation or the source of law, it comes from our Constitution, but the detail has been established under the Courts Establishment and Constitution Act of 1961. So the establishment of our new court system has been set out in legislation, which is another source of law within the Irish legal system. So we're going to look at, as I said, we're going to look at the court system, which is based, it has its foundations in the Constitution, and then the structure of the courts, in particular looking at the hierarchy of the court system that we have in Ireland. So we have a hierarchy going from top to bottom, if you will, going from the Court of Final Appeal, which is our Supreme Court, all the way down to courts of local and limited jurisdiction, which is the district court. So I'm going to take you through each of the court structures and compositions and the jurisdiction, and I'll explain some of those terms as I'm going through the lecture. So the Constitution, as I said, sets out our structure, and the structure is that we have a Court of Final Appeal known as the Supreme Court. Through a recent amendment, we now have a Court of Appeal that sits between the Supreme Court and the High Court. So we have a Court of Final Appeal, a Court of Appeal, and then we have Court of First Instances, which are referred to as the High Court, which has full and original jurisdiction to hear all cases in civil and criminal matters. And then we have courts of local and limited jurisdiction, which are the Circuit Court and the District Court, and they're based or organised on local and regional basis. And we'll go through each of these different courts and their composition and structure. So first of all, just to talk about the administration of justice, which, as I said, referred to earlier, is found in Articles, in particular in Articles 34.1 of the Constitution and also Article 37.1 of the Constitution. So I have a quote here for you to have a look at, and just to think a little bit about it and to pull out, I suppose, the essential elements of what administration for justice means in the Irish court system. So justice shall be administered in courts established by law, by judges, appointed in a manner that is provided for by the Constitution, and save in such special and limited cases as may be prescribed by law, shall be heard and administered in public. So there's a number of things here, and I'll take you through them. The first one being justice shall be administered in courts, so we must have a court system, by judges, and shall be heard in public. So those are very important functions of the court system in relation to the administration of justice. And then we have Article 37.1, which basically says that nothing in this constitution shall operate to invalidate laws that provide or give limited functions to other bodies to act in a judicial-like capacity, except for in criminal matters. So we have Article 37 here that is basically saying that the legislature can provide in law for the delegation of powers of a judicial-like nature to other bodies other than the courts. So the importance here is that it will be limited functions, so it can delegate limited functions to other bodies, and examples of bodies in this context are often state bodies such as the Labour Court, the Ombudsman, arbitration, and other statutory bodies are examples, such as the Law Society of Ireland. It has statutory functions in relation to the regulation of solicitors here in Ireland. So the important aspect here is that their functions are limited. So they've limited functions, and this is often will be seen in the law through a appeal to the Circuit Court or an appeal to the High Court from any decision that may be given by a state body. So for example, in the Law Society of Ireland, they have a function in relation to the discipline of the profession of the solicitors, but any matters that warrant issues in relation to the administration of justice, there will be an appeal to the High Court, for an example. And there was a case in relation to that where the Law Society did not have the power to strike a solicitor off the list. That is to be kept for the High Court. So the functions of the court in relation to the administration of justice. So the function of the court is the interpretation and the application of law being either constitutional provision or statutory provision or case law, so the doctrine of precedent and earlier decisions of the courts in the judicial hierarchy. So importantly, the administration of justice centres around the power of judges to interpret and to apply the law. So I referred to earlier an Article 34.1 of the Constitution. It says that justice shall be administered in court by judges and generally heard in public. So the exception to the cases being heard in public is the Incamera Rule, which basically means cases will be heard in private, but only in exceptional circumstances. And the Constitution gives authority to the legislature to enact legislation to provide for situations where cases can be heard otherwise than in public. So I'm going to give an example here. And otherwise than in public, the in-camera rule generally will mean that members of the public are not allowed in the courtroom when a case is being heard, and typically it will be just the judge, the parties and their legal representatives, or the jury if that's applicable. So when the Constitution generally says that it gives authority to prescribe by law or as will be established by law, it generally will mean that the legislature, the Oireachtas in Ireland, which is the sole and exclusive lawmaking body in the country, will enact a piece of legislation to provide the detail in relation to, in this context, in relation to when cases will be heard in private or in camera. So there's a number of there's 4 different circumstances here that are provided for under the Court Supplemental Provisions Act of 1961. So in the 1961 Act it says that cases can be heard otherwise than in public in applications of an urgent nature, such as habeas corpus, ex parte, for example, applications might be heard in camera, matrimonial causes and matters, lunacy and minor matters, and proceedings involving the disclosure of a secret manufacturing process. So those are a couple of examples, and I want to just illustrate the application of the Incamera Rule by looking at matrimonial cause, or the area of family law, and how it operates in that context. So we've had since the 1961 Act that I've just referred to, that provides for exceptions to cases being heard in public, so cases being heard in camera in the subject area of family law. So this provision has been very strictly applied from 1961 up until 2004, where we had another enactment, another piece of legislation from the Oireachtas, which basically relaxed the Incamera Rule in the context of, or in the area of family law. And the reason for this is that there had been a number of reports published criticising the Incamera Rule in the context of family law, because of course it was a barrier, an obstruction to access to justice. So people, and the legal profession in particular, didn't know how the law was operating, how the reasoning and the arguments of the judges when they were determining decisions in the area of family law. So you have the Civil Liability in Courts Act of 2004, which amends the In-Camera Rule to allow for other key stakeholders to have access to judicial decision making in the context of family law. So we had the relaxation of the rule. It allowed for barristers and solicitors or other researchers to prepare and publish court judgments in the family law area. Fast forward then until 2013, and we had another amendment, another relaxation of the In-Camera Rule under the Courts and Civil Law Miscellaneous Provisions Act, and this basically relaxed the In-Camera Rule again to ensure or to allow the media to have access and to report on the area of family law. The In-Camera Rule is there to really to protect, in the context of family law. It's about the balancing of the private rights of the family and the right of the public to know or to have access to the law and to judicial decision making. So cases should usually be heard in public, with the exception of cases as provided for in law, can be heard in camera, and as I said, one example is in the area of family law. So just a couple of terms that I want to explain a little bit in relation to the court system and the jurisdiction of the court. So there's we've just spoke about the administration of justice and the system of the court that has been set up through both the Constitution and then through legislation. And now we're going to look at the hierarchy or the structure of the court system and the jurisdiction of each court and the function of each court in relation to civil and criminal matters. So what does jurisdiction mean? So jurisdiction basically means to say the law, or it's where a court has jurisdiction, it has the power to hear and to determine a case. You'll also hear terms like local and limited jurisdiction, and local and limited jurisdiction generally relate to the circuit court and the district court, who have local and limited jurisdiction according to the Constitution and to legislation. And local means that it is local. Its jurisdiction is related to the geographical location, and limited is typically in relation to either limited to a monetary value, or the term of imprisonment if it's the criminal jurisdiction, a monetary value if it's compensation and it's the civil jurisdiction, or else the subject matter or the legal issue at hand. So you'll see that it is limited by maybe the subject matter, or a monetary limit or a monetary amount, or indeed a term of imprisonment if it's the criminal jurisdiction. But we're going to go through each of them according to each court within the Irish court structure. Original jurisdiction refers then to the again, the authority or the power of a court to hear and decide a case. So, for example, the High Court has full original jurisdiction in all matters of civil and criminal. However, the District Court and the Circuit Court does have original jurisdiction, but it's limited, as I said, generally by legal subject or by monetary value or term of imprisonment. And then appellate jurisdiction refers to the authority of a particular court to hear a case on appeal. And within the Irish court system and the appellate jurisdiction, there's generally two formats of appeal. So you can have a de novo appeal, which is a full rehearing of the appeal. For example, a case that has been decided in the District Court and is appealed to the Circuit Court, there will be a full de novo rehearing of the case. So that's one of the appellate forms of appeal. And the second form of appeal is an appeal on a point of law or a case dated. So often you will have an appeal on a point of law from the District Court or the Circuit Court to the High Court, where a District Court judge might pose a question and ask the High Court to interpret a particular statutory provision to determine if the District Court has applied that provision correctly in the context and the facts of a particular case. So we're going to go through the hierarchy, as I said, of the courts and the different jurisdictions, civil and criminal in each, and the composition as well in relation to each of the courts. But we also refer back to the source of setting up the court structure and the court system. We have Article 36 of the Constitution, which basically is the authority stating that the courts shall be regulated in accordance with law, which is the function then of the Oireachtas to legislate for this area. And basically, Article 36 talks about the regulation of the distribution of the jurisdiction within each courts, and the approach of the legislature has been then to divide up the functions between each courts. So I have a diagram here of an example of the hierarchy of the court system. So you'll see the civil jurisdiction and the criminal jurisdiction will go up through the hierarchy of courts, typically in the same way, except for with the criminal jurisdiction, you will see that the High Court sits as a central criminal court when it's sitting in its criminal jurisdiction, for example, and it's in its civil jurisdiction, it will sit as a High Court. There's also divisions in the civil jurisdiction where it might sit to hear commercial cases. So you'll have the commercial court, and there's a list for commercial cases that go through the civil jurisdiction of the High Court. So we start off with the District Court, the Circuit Court, the High Court, and it goes on then to the Court of Appeal and then the Supreme Court. So the Court of Appeal is a new level within our court structure, and that came into play when the Constitution was amended to insert a Court of Appeal between the High Court and Supreme Court. And the function of the Court of Appeal is that it is appellate jurisdiction, but it was mainly brought in to reduce the backlog of cases that was going to the Supreme Court. So now we will have appeals from the High Court typically going to the Court of Appeal rather than the Supreme Court, and this allows the Supreme Court to have time to deal with cases that have constitutional public interest. Typically will be kept for the Supreme Court. So we'll go through each of the different courts and we will look at the composition and the jurisdiction, as I said. So in our district court system, we have 24 districts around Ireland, so it's local. It has a local jurisdiction. It typically consists of there'll always be a president, so there's a president of the district court, and it has 63 ordinary judges. So you'll find from the district court up to the Supreme Court, you'll see the number of the judges being reduced as you go up. The district court takes a lot of the is probably one of the busiest of the courts. So there's 63 ordinary judges that sit in the 24 districts. Matters are usually heard by judges alone, so you'll typically have one district court judge sitting to hear a case. And it has original jurisdiction, again to hear cases across criminal and civil jurisdictions, and we will have a look at each jurisdiction. So if you look at the district court and its criminal jurisdiction, it's limited, so it's local in that it's limited in geographical area, and then it's also limited to minor offences. So there's been no definition of what minor offences means, but typically a minor offence will have two characteristics. It will be minor in the sense of the severity of punishment, and minor in the sense of the culpability of the moral behaviour or the conduct. So for example, murder is not a minor offence, that is held for the jurisdiction of the High Court, for example. So minor offences are typically heard in the district court, and generally we'll look at the severity of punishment, which is a maximum of 12 months sentence within the district court, for example. So there's no jury trials which differentiate the district court from the circuit court system in relation to the criminal jurisdiction. So examples, I have examples here. So if we're talking about minor offences, generally it's minor theft, minor assault cases, and most road traffic offences will be heard in the district court. It also has jurisdiction to hear cases in relation to the granting of bail, and there's an appeal from the district court to the High Court in relation to bail. And as I said, there is generally a maximum term of imprisonment for 12 months or a fine of €5,000. So the civil jurisdiction of the district court, and I said earlier in relation to the limited function, is typically will be, especially in the civil jurisdiction, it'll be a monetary value or monetary limit, and in the context of the district court it is €15,000. So it will hear civil claims that do not exceed €15,000 in the district court, and it's also limited to the types of cases that it can hear. So for example, it'll hear cases on the subject matter of contract law and family law, and it would be limited, for example, in the context of family law or childcare proceedings, to custody and access. Whereas it cannot hear cases in relation to judicial separation, nullity or divorce, which belongs to the jurisdiction of the High Court, and actually also the Circuit Court has concurrent jurisdiction in relation to that area. So as I said, it does deal with family law, but it is restricted or limited to hearing cases around maintenance, custody and access. Also it can hear and has original jurisdiction to hear cases under the domestic violence legislation. So it can give orders in relation to barring orders, safety orders and protection orders. It also has a jurisdiction to renew liquor licences. It's the renewal of liquor licences. You will make an application to the district court, but if it's for a new liquor licence, you typically make the application to the circuit court. So that's the district court. And the circuit court then, there are 8 circuits in Ireland, and they are based on a regional basis around the country. So we have 8 circuits, and that will consist of a president of the circuit court, and then there's 37 ordinary members of the circuit court. And you'll find this in the composition of every court. The president of the district court is an ex officio or special member of the circuit court, and you'll have the same across all. So you'll have the president of the circuit court will be ex officio member of the High Court, and the president of the High Court will be an ex officio member of the circuit of the Court of Appeal, and so on. So matters are typically heard by one judge sitting alone. When it's in its civil jurisdiction and criminal jurisdiction, and in its criminal jurisdiction, it will sit with a jury. So the Constitution says that criminal matters heard through indictable offences will be heard by a judge and a jury. So there are cases also in the civil jurisdiction of the circuit court where it will be where a jury will hear the case, and that is in the area of defamation is one example. So just to look at the different jurisdictions then in relation to the Circuit Court. So it is a court of local and limited jurisdiction, as I said, similar to the District Court. So it also has jurisdiction in relation to civil and criminal matters. It has original jurisdiction, so typically depending on either the monetary value of the award that will be given, so the monetary limit, and also the subject matter of the area of law. It also has appellate jurisdiction, so it both hears appeals from the District Court and can appeal cases to the High Court within the judicial hierarchy. So the civil jurisdiction in the Circuit Court, again, it's related to compensation. So you can take a case, usually it will be taken to the Circuit Court in relation to either private law areas such as contract law, tort law, where the compensation will exceed 15,000, but up to a maximum of 75,000. So there has been some changes and some amendments to the jurisdiction of the Circuit Court. So typically, claims should not exceed 75,000. However, on the consent of all the parties involved, the Circuit Court can hear cases that will exceed that amount. And that change really was made, one of the main reasons it was made was a monetary reason again, was to ensure or to reduce the legal costs for litigants that might have to go to the High Court. So it's cheaper to go to the Circuit Court. So again, it can hear all types of cases in contract and tort law. It can also hear disputes in relation to land law, and can give many of the equitable remedies, such as injunctions and specific performance, and damages, obviously, also. So when it deals with family law matters, it is referred to as the Circuit Family Court. And as I mentioned earlier, its jurisdiction in family law is in relation to judicial separation, nullity and divorce proceedings. So it's criminal jurisdiction. So while cases will be heard in relation to minor offence in the district courts, the Circuit Court will try cases on indictable offences. So typically it's cases that are more serious and that will be heard in the District Court, but less serious than that might be heard in the High Court. So for example, cases relating to murder and rape will be heard. It has original jurisdiction in the High Court to hear those types of cases, but more less serious offences such as maybe aggravated assault, theft, damage to property, that aren't of a minor nature. So typically that will attach a term of imprisonment more than maybe 12 months will be heard in the Circuit Court. So the High Court then. So the High Court's location is in Dublin typically, but it does travel around on circuit around the country. So you will have the High Court sitting on circuit in different locations around the country. The High Court will consist again, there's a president of the High Court, and you have 37 ordinary judges in the High Court, and you will have the president of the Circuit Court sitting as an ex officio member of the High Court, as I mentioned earlier. So matters will usually be heard in the High Court by one judge, but it can sit in divisional courts, which are 2 or maybe 3 judges. And its jurisdiction, again, it has original jurisdiction according to the Constitution to hear all cases of civil and criminal matters. So its jurisdiction is not local or limited like the District Court and the Circuit Court. So just to look at some of the functions of the High Court, or its jurisdiction that may be different from the District Court and the Circuit Court. So it has an appellate jurisdiction, so it does hear cases on appeal from the lower courts, but it also has a supervisory function or supervisory jurisdiction. So it supervises decisions of inferior courts, but also state bodies. So one of its an example of a supervisory function is judicial review. So it here's judicial review cases, and that is its supervisory jurisdiction. And in the context of its supervisory jurisdiction, it has the power to make orders either preventing an act or an action, or mandating that a particular action be taken. So you have prohibitory injunctions and mandatory injunctions, which the High Court can make in relation to a remedy of a particular dispute, for a particular dispute. So it also hears all civil matters, typically that exceed the 75,000 limit that has been applied in the Circuit Court. It also has functions in relation to the Companies Act, and I mentioned earlier, now when the High Court sits in its civil jurisdiction in relation to commercial cases, typically when they're over the value of 1 million, it will sit as a commercial court to hear cases that might come under the Companies Act, for example. It also has full and original jurisdiction to hear all cases of a constitutional nature. So any case in relation to provisions of the Constitution or the fundamental rights of each citizen, or any provision in the Constitution. So any challenges to the validity of legislation, whether legislation is compatible with the Constitution, for example, will be heard in the High Court. So it's criminal jurisdiction. So when the High Court sits in its criminal jurisdiction, it will sit as the central criminal court. And that has full and original jurisdiction under the Constitution to hear all matters of a criminal nature, and it will sit with a judge and jury. So until 2014, we have had the High Court in the judicial hierarchy, and then the Supreme Court. Now we also have, in between the High Court and the Supreme Court, we have a new court, which is the Court of Appeal. And the Court of Appeal has mainly an appellate jurisdiction, and it's set out in the Constitution, but also in the Court of Appeal Act. So the Court of Appeal sits in Dublin only. There is a president of the Court of Appeal, and there are 9 ordinary judges that sit on the Court of Appeal. You will have the Chief Justice of the Supreme Court and the President of the High Court sitting as special members of the Court of Appeal, or ex officio members of the Court of Appeal. Matters can be heard in the Court of Appeal. Similarly to the High Court, it can sit as 1 judge, or it can also sit in divisions of 3. So as I said, it has appellate jurisdiction, so it can hear all cases of civil and criminal matters that are on appeal from the High Court or from the lower courts in limited circumstances. So the Supreme Court then, the Supreme Court is our court, it's our ultimate court of final resort. So it's a Court of Appeal. It has its foundation in the Constitution. It sits in Dublin in the 4 courts, and it will consist of a Chief Justice and 9 ordinary judges. You will also have the President of the High Court and now the President of the Court of Appeal sitting as ex officio members of the Supreme Court. Matters will be heard in the Supreme Court in different divisions. There can be a 3-judge Supreme Court, 5-judge, or in exceptional cases a 7-judge Supreme Court. But if the Supreme Court is hearing cases of a constitutional nature, it will hear the case with at least 5 members of the judiciary sitting to hear that case. So it's while the Supreme Court is a court of final appeal, it has an appellate jurisdiction, but it also has original jurisdiction in 2 particular areas, and that's Article 26 and Article 12 of the Constitution. So it has original jurisdiction to hear Article 26 references, and Article 26 basically states that the President can refer bills to the Supreme Court to test the constitutionality of that bill. So it's a role or function of the President, and the President, if it believes that a bill that's passing through the legislative process in the Oireachtas is incompatible with the Constitution, it can send that bill forward to the Supreme Court, and the Supreme Court can test the constitutionality of it, whether it is compatible or not with the Constitution. So that's its original jurisdiction in relation to Article 26, and also Article 12 of the Constitution said that the Supreme Court is the only court that can determine whether the President is incapacitated and if so, should be removed from office. So that's Article 26 and Article 12. So as I said, the Supreme Court is a court of final appeal. It's authoritative in our judicial hierarchy, in the hierarchy of our courts. So it has appellate jurisdiction and often hears cases from the lower courts. But with the amendment in the Constitution in relation to the creation of the Court of Appeal, the Court of Appeal is to take over most of the backlog of cases, to free up the Supreme Court for cases of more public general interest and public importance or constitutional matters. So there is exceptional appeals from the High Court and from the Court of Appeal to the Supreme Court, but generally it has to meet the threshold criteria that's set out in Article 34 of the Constitution, which says the Supreme Court will hear cases on appeal from the High Court or from the Court of Appeal in two cases, and that is where the decisions involve a matter of public importance or in the interest of justice. So while typically, or going forward, cases in the High Court that have to be appealed should go to the Court of Appeal, there can be what has been termed a leapfrog from the High Court to the Supreme Court if the case in the High Court meets the two threshold criteria that I have just set out. So the Special Criminal Court, we also have a Special Criminal Court. The Special Criminal Court was set up to deal with cases of a criminal nature that can't be properly heard in the criminal jurisdiction of the other courts in the hierarchy. So the district, circuit, or the central criminal court. So specifically, it sets out in the Constitution that the legislature can establish special courts, and it says where the ordinary courts are inadequate to secure the effective administration of justice and the preservation of peace or order. So one example of cases that go to the Special Criminal Court or that are cases in relation to organised crime, where there may be issues around the intimidation of the jury, for example. So there's 11 members, which are generally taken from the High Court, the District Court and the Circuit Court. 3 judges will sit to hear a case in the Special Criminal Court. 1 judge from the High Court, the High Court, the District Court and the Circuit Court. It will sit with no jury and it will deliver 1 judgment. So if you're looking for examples of the offences that can be taken to the Special Criminal Court, that's outlined in the Offences Against the State Act. So criminal damage or sheds referred to as scheduled offences under the Offences Against the State Act, but also there is room for appeals to the Special Criminal Court for non-scheduled offences if certified by the Director of Public Prosecution for it to be sent to the Special Criminal Court. So that's the hierarchy and the jurisdiction in the Irish court system of our court. So you have from the Supreme Court to the District Court and judicial hierarchy, you have different jurisdictions, civil and criminal matter at each level. But we also have to take into account European courts. So because EU law is a primary source of Irish law, the European Court of Justice can hear appeal cases in relation to the interpretation or the application of EU law. And then, because we've incorporated the European Convention on Human Rights into Irish law in the European Convention on Human Rights Act, we also have to consider decisions of the European Court of Human Rights. So there is also an appeal to the European Court of Human Rights on matters related to the compatibility of Irish law with the Convention, for example. So that's the court system, and that's the structure of the courts within the hierarchy of the court system as set out in our constitution and legislation. There are also just some final issues, and I've already referred to them as I went through the jurisdiction and talked about some of the remedies, but there's remedies that apply in civil matters and criminal matters. So for example, we have under the civil jurisdiction, the court, when it's resolving a dispute and it sets out its decision and will hand down a remedy to the plaintiff, for example, it will typically be monetary compensation in the civil jurisdiction. So damages would be the term used. It also has jurisdiction to hand down injunctions, declarations and specific performance, which I have referred to, particularly in the area of contract law or tort law for damages. And then the criminal remedy, which I have referred to, is typically will be imprisonment or a fine or community service, maybe another remedy in relation to the criminal jurisdiction. So just to summarise, basically I've set out a number of questions here that if you want to do a little bit more research in this area or to think about the concepts and the rules and the principles and the structure and the hierarchy of the court system that I've been talking about. So what sources of law provides for the establishment of the courts? So earlier I have presented a lecture on Introduction to the Irish Legal System, which covers sources of law, so you might have a look at that if you want a bit more detail on the sources of law. But typically the source of law here has been the structure and system of the court is set up by the Constitution and by legislation. So we've looked at the differences in civil and criminal jurisdiction and the different appellate and original jurisdictions in each of the courts, the hierarchy of the courts. I've also just highlighted some reading here, resources. So if you want to do a little bit more research or go in into depth or into detail a bit further, you can refer to Byrne McCutcheon, for example, or also there is an Introduction to Law handbook that will be available for you on the law school's website. So you might have a look at that. Thank you.